Yeah. Two. Yeah. Aye. I'm jacking the beat, you calling the cops, the yapping is cheap, I call you the ops, the rapping is heating, it's all cause of pop, you get a leak for the ball, get a drop, feel like I'm wrong when I double it back, cause I'm making it harder to catch that, but I covered the ticket, I call you to visit, you tipping and hit up the cash app, baby girl been round for it, yeah, in the old days, I was stuck in old ways, never really trying to flip the old page, young man tripping at an old age, thinking I was flicking, had a low wage, led the bro days, then a slow praise, thinking it'd be different, it would gon' change, then it really didn't, it's a cold game, yeah, ayy, all I really wanted was the money in the pocket, got over money, but the money ain't a topic, like Bill Doe and the money gotta stop it, kid need food and the whip need juice, I'ma get these views when the work hard, play hard, homeboy, everybody ain't calling out. Got a mouthpiece from the southeast, if you want scrap, stall him out. If you don't know what I'm talking about, then I feel good, man, I'm balling out. I'm a rich man with a rich fam, Christ bars got me out of mama house. And I bless God, give thanks. Bless God, give thanks. Bless God, give thanks. Bless God, give thanks. Big God, big grace. Big God, big grace. Big God, big grace. Big God, big grace. Bless God, give thanks. Bless God, give thanks. Bless God, give thanks. Bless God, give thanks. Big God, big grace.
What it do, y'all? It's your partner Dale, looking fresh, cold, clean, guys. And again, welcome again to another edition of the Countermove podcast, where we look at life from a wise perspective, lean in and reason together, guys. And like I always say before, if you are looking for a debate, do me a quick favor, hit that X button at the top left hand or right hand side, and bounce, guys. Because on this one, we are not trying to debate. We're trying to lean in and reason together, guys. All right, and y'all, real talk, guys. To be honest with you, something actually happened this week, and this was a very really historic week when it comes to what's going on with Trump. As you guys know, uh, President Trump was indicted for the second time. And like I did on the first Kind of Move podcast, I dove into it a little bit as well. But I really wanted to look at it from a legal perspective, not a political perspective, a legal perspective. So I've had quite a bit of phone calls with attorneys. And as you guys know, attorneys have different disciplines, guys. And we got nice little people on YouTube as well. I see you, Mo. What's going on with you, Jacqueline? I see what's going on with you. I see what's going on. I see you. I see y'all, man. Good stuff. Good to see you guys. But I want to dive into this real fast, guys, on President Trump being indicted for the second time. And as you guys know, when it comes to attorneys have different disciplines. You have for instance, real estate attorneys. You have prosecutors. You have litigators. You have um, M&A attorneys. You have ethics attorneys. You have a lot of attorneys that have different disciplines. All right. And the one thing that I've been seeing a lot of the times is really on TV, there's been really just one form of attorney that's actually been on the scene. That's former federal prosecutors. All right. And they're speaking about a subject that was very interesting to me. And of course, special counsel Jack Smith came in and actually indicted him. Right. And we're going to walk through those counts line by line, all right? But I wanted to bring in someone that could actually unpack this a little bit more. He is conservative, but he's a constitutional attorney. He's the former chief of staff for former Attorney General Ed Meese, good friend of mine. Been on the show several times, this radio show several times. Good guy, and that's Mark Levin. And what Mark Levin talked about is he talked about, I wanted to bring him in to bring a constitutional type of mentality to it because realistically you have the Presidential Records Act going on and then the Espionage Act really going on. So let's kind of bring him in real fast and and let him unpack what's going on. Okay. Now, again, he is conservative, but when it comes to unpacking of the legalities behind it, that's what I wanted to really want to focus on, guys. So let's dive into this real fast. Let's bring in Mark Levin real quickly, and let's see him kind of unpack some stuff, and then we can begin to reason together. All right, guys. So let's see what Mark has to talk about it. And what we're going to do is we're going to talk about how did we get here? Okay, how did we get here? So Mark, man, help us out, big dog. Here we go.
Welcome back, America. Well, by now you've heard a lot about this. This is the indictment, the various charges against President Trump. It's 49 pages long. There are 38 charges, 37 involving President Trump. The one against Waltine Nauta, who's a Navy vet and an aide to President Trump, is in here in order to try and pressure him to turn on Donald Trump. That's why they put it in here.
If that is a fact, that's kind of fishy. But I digress. Let's keep going.
Now, some people are very impressed by this. I am very troubled by this.
Okay.
37 counts against the former president and the leading Republican nominee right now for the Republican nomination for president.
Okay.
31 having to deal with document retention. Why would you pile on 31 counts when it could be one count or 3 counts or 5 counts? The answer is they want to put Donald Trump in prison. And as I said last week when I was on Hannity, Donald Trump is 76 years old. Some of these counts have 20 years, 10 years on them. If they convict him of one count and he's sentenced to the full amount, he will die in prison. That's how out of control Biden and Garland and this hack prosecutor are.
Okay.
Now, there's some things missing from all this.
Okay.
Despite all 49 pages and all these witnesses and all these documents, what's missing? Obstruction and false statements and this, that, and the other, which are born out of the fact that they criminalized this investigation, as I explained earlier. Had they not criminalized this investigation, none of this would be an issue. So they lay the foundation for conspiracy to obstruct, and all this sort of thing.
Okay.
But what's missing? Retention of documents. There is not a single syllable in this 49-page, 38-count indictment, 37 against Trump, about a single document being destroyed. Not one. You would think if they had evidence of that, it would be right there in the first charge. Number 2.
Now, it's fair to say this here. Mark's right about that. Typically, when it comes to an indictment, from what I've been advised by a lot of attorneys in different disciplines, an indictment has mostly your best stuff. Now, it's not going to lay out the evidential case that they're going to lay out in the courtroom, but typically it's one-sided, number one, because it's in front of a grand jury. And then number 2, what happens is you give out your best stuff in this, okay? So watch how Mark unpacks this, all right? Again, from a constitutional standpoint, okay?
Number 2, there's not a single syllable in this document alleging that any document was altered. Not one. If there was, and they had evidence to that effect, you'd think that would be in the front.
Yep.
Instead, they're attacking the former president for retaining documents, classified documents, talking about the classified documents. There's not one syllable of evidence in here that any information under the Espionage Act was passed to any spies, to any enemies, to any foreign countries. Not one. The Espionage Act was passed in 1917 under the tutelage of Woodrow Wilson, who was a racist segregationist, and he locked up 2,000 people, the vast majority of whom were innocent because they disagreed with his position. There's something wrong with such a statute.
Okay.
And so this is written for a Democrat jury. And even though the jury will be in Miami, assuming it gets to that point, and it shouldn't, it's going to be filled with Democrats because the most southern part of Florida is filled with Democrats. No, it's not New York, it's not Washington, but it's not Idaho and Utah either. So I want you to keep that in mind. They figure if we can get them on one, The other thing is they have all the resources in the world because they're the government. They're the government. So Donald Trump's lawyers are going to have to take all of this and try and unravel it.
Yeah.
That's also one of the reasons they pile on. It's also one of the reasons they had hundreds and hundreds of witnesses, from the janitor to the vice president of the United States. And that's also why they had tens of thousands of documents, because now a private law firm, relatively small firm, is going to have to try and figure out how to unravel what the prosecutor did. Now, I want to remind you of a few things about a grand jury. All it takes is a majority of the people in a grand jury, typically up to 23 or so, to vote to indict. So if it's 23 members or if it's 21, whatever it is, it just takes 12 in Washington, D.C. or in Miami. It takes 12. That's number one. Number two, no witness, no target is permitted to have counsel in front of this grand jury. You're there by yourself in front of prosecutors asking questions, and many of them driving an agenda. That's number two. Number three, you're not permitted to provide the grand jury with any exculpatory information or contrary information to what the government's feeding them. Grand juries were intended to protect potential defendants against an overwrought and zealous government, but now they've been used. It's been twisted. They're used against individual citizens and so forth, as they've been used against Donald Trump. And so aggressive and out of control is this prosecutor that he went to a Democrat Obama-appointed judge who he knew would give him what he wanted, because her record has been to reject every single motion filed by Donald Trump's lawyers, because she's the motion judge. She's the chief judge in Washington, D.C. when it comes to these grand juries. She gave him again what he wanted. He wanted this prosecutor to get testimony from President Trump's lawyers, including his lead lawyer, about conversations President Trump had with.
Now, I want you guys to understand this, because I want you to see how we got here. I want you to hear the entire context up front. And what Mark is actually saying is he's saying that President Trump's own attorneys were forced to testify against him because of the stretching of the law. He's going to go into this in a second of how that actually happened. So he was confined to who he could actually talk to, and then his vice president went in front of him, and the janitors, everybody in their mind went in front of this grand jury. Again, it's one-sided, but I want you to understand how we got to this indictment first. Okay, here we go. Almost done. All my legal eagles, listen.
Had with that lawyer, and the notes from the lawyer. I suspect some of that is in this document. And so what he's done is he's taken pieces and puzzled together cherry-picked testimony from this witness or that witness, nothing exculpatory in here, no exculpatory testimony or documents, and he's chiseled it and pieced it all together, so you are left with a document that says Donald Trump was a grave threat to the country, the way he handled classified information, the way he handled documents and so forth, the way he retained them, the way he tried to cover up. He moved boxes. He told people to move boxes. He motioned somebody about getting rid of something, which is why I started out this segment by asking, how many documents were destroyed? There's not an allegation in here that any documents were destroyed, not even one. How many documents were altered or molested? There's not an allegation in here that any were altered or molested, period. False statements, conspiracy to obstruct, retention of documents, obstruction. All of this comes out of the criminalization of this case, and this is what prosecutors do, and what this prosecutor, this Justice Department, this Attorney General, and yes, this President Biden have done, is they have destroyed the country. And I don't know if we can ever get it back. They've destroyed something that matters to each and every one of us. They talk about suppressing the vote. They've destroyed the next election. They've interfered with the next election. This isn't natural or normal for America. This is taken out of the Joseph Stalin playbook.
So, guys, that is Mark Levin. They call him the Great One. He's one of the best I've ever seen at really unpacking the law from a constitutional standpoint. And so that was how we got here. So he explained how we got to the scenario of President Trump being indicted for the first time, first president ever in history. So he talked about how they did this, okay? And how when it came to a grand jury, it was really all one-sided, and that's not uncommon. That is what grand juries are normally about, which to me is really kind of unfair, to be honest with you, in my opinion, no matter what side of the aisle you're on. But they make an indictment, and then what happens is he talked about how they pieced it all together. Now, guys, again, I said my legal eagles. Okay, this is not going to be one of those spicy ones. But there's two different statutes that you keep hearing about in the news, guys. And those statutes are it is the Presidential Records Act, right? And the Espionage Act. If you're looking at CNN, MSNBC, ABC, NBC, CBS, Fox Business, you name one, pick up a letter. They're talking about these two statutes, the Presidential Records Act and the Espionage Act. They actually charged President Trump with the Espionage Act. So I thought it would be wise to bring Mark back in to realistically look at both of these statutes, guys. I want you guys, he's one of the best I've ever seen at breaking stuff down. Okay, guys? So let's walk through this real quickly, guys. Okay? All my legal eagles, you're going to love this. Here we go. Let's get into this.
Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin, and this is also a sad day in American history, one of the saddest, quite frankly. The Democrat Party and the Biden administration know no limits for the retention of power. Simply no question about it.
Now, I just saw a comment on Instagram. Thank you guys for choosing on Instagram. One of the question was, what do we do? It feels hopeless. At the end, I have a Countermove. This is called the Countermove podcast for a reason. At the end, I give you a Countermove, all right? Here we go.
Joe Biden said the other day that he had nothing to do with any of this when it comes to the investigation of Donald Trump. He's a liar. He's a liar about shell corporations. He's a liar about money from communist China. He's a liar about money from Ukraine, a liar about money from Romania. He's a liar about documents. He's a liar about his own history. We have a man in the Oval Office who is a pathological liar. But that said, Biden signed off on FBI review of Trump records, National Archives letters reveal. This is from August.
So hold on now. So Biden signed off for the archives concerning the documents on President Trump. New information about this. New information. Let's keep going.
August. What are they talking about? Biden White House, at the request of the Department of Justice, signed off to have the FBI and intelligence community to examine hundreds of pages of classified information former President Trump had. NARA informed the Department of Justice about the discovery, which prompted the department to ask the president to request NARA to provide the FBI with access to the boxes at issue so that the FBI and others in the intelligence community could examine them. So there you have NARA going to the Department of Justice,
Wow.
which is extraordinary.
Yes, it is. Wow.
The Department of Justice saying, wait, you can't come to us directly. You have to go through the White House. Then they go back, circle back to the White House counsel's office, and Joe Biden. And they agree to send the matter to the Department of Justice, knowing damn well what would happen. And that's what triggered the entire thing.
So the White House is involved in signing off on NARA. NARA advises the White House. They advise that you have to go to the White House to get that done, right? And then Biden signs off on it to get it over to the Department of Justice and the FBI. So now we got some hands in this a little bit. Okay, let's keep going. This is very important because none of this can happen without these steps. That's why NARA, right, pointed them over to the White House. Let's keep going.
General warrants, the Fourth Amendment of your Constitution, the Bill of Rights. This warrant that was issued by a federal magistrate judge. The framers of your Constitution hated general warrants, or what were called writs of assistance. Why?
Okay.
Because they were used by the king to rummage through their homes, to rummage through their businesses in search of criminal behavior. And federal prosecutors have been chopping away and chopping away and chopping away at this over the years, now to the point where they have chopped it off a limb in the case of Donald Trump. Here's what your Fourth Amendment says.
Listen.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So what's probable cause?
Yes, good question.
That is a reasonable basis to believe a crime was committed.
Wow.
They had no reasonable basis to believe a crime was committed, even if Donald Trump had classified information, which he did. Because it's not a crime. It's not a crime for him to possess it. Not under the Espionage Act or any other law.
That's correct.
When Donald Trump left the White House, he was president of the United States.
Yes, sir.
When he arrived at Mar-a-Lago, he was president of the United States.
And I want to make this statement. He got to Mar-a-Lago before Biden was inaugurated as president. So when he landed, he was still president. But before he even landed, before we go to Mar-a-Lago, I may be off when he landed because it's a nice little flight from Washington, D.C. to Florida. But, you know, he had a speech before he took off. Well, those documents were uploaded in. When he had that speech, he was still president. Still. He is no longer president until Biden is sworn in. Listen, guys.
Whatever he took with him, you cannot then turn around and say he violated the Espionage Act of 1917.
Yes.
And try and charge him with espionage.
Listen.
And DOJ did not act in good faith, which is required under these circumstances, too. America's founders hated general warrants. Hated them.
Now, he's saying general warrant because there was no probable cause. As you read about in the Fourth Amendment, there had to be a reasonable probable cause, right? That's why he's pointing toward the Fourth Amendment. And so he's saying that the founders hated general warrants because in Britain, the king loved those things. So they put that Fourth Amendment in for this specific situation, all right? So he's saying, what was the crime? And now you're going to understand, you're going to finish see how they went from criminal to civil in a second. This is a brilliant breakdown, guys. Keep going.
But the government has resurrected them. Remember the other day there was a report that, oops, we're sorry, we have 1 million cases where innocent citizens were monitored.
Yeah.
Remember that? That's a general warrant. Here's a piece from the Washington Post several years ago by Henry Farrell. 4 centuries prior to the U.S. founding, English jurists and legal scholars rejected general warrants as the worst exercise of tyrannical power. As Sir Edward Coke announced in Parliament in 1628,
listen,
if general warrants be used for the matter of the state, then we are gone, and we are in worse case than ever. If we agree for matters of state, we shall leave Magna Carta and other statutes and make them fruitless, and do what our ancestors would never do. Sir Matthew Hill, William Hawkins, and others went on to condemn them, as did our founding generation. Now they're in use. Here I have it. Here's the warrant.
There you go. Listen.
The warrant says, among other things, the search warrant, not including the affidavit, signed and approved by the court, August 5, 2022. And in part it says, attachment A, the premises to be searched, which they mentioned Mar-a-Lago. It is described as a mansion with approximately 58 bedrooms, 33 bathrooms on a 17-acre estate. The locations to be searched include the 45 office, the president's office, all storage rooms, all other rooms and areas within the premises used or available to be used by the First Lady or the President and his staff, and in which boxes or documents could be stored, including all structures or buildings on the estate. Sounds pretty broad to me.
Yeah.
It does not include areas currently, at the time of the search, being occupied, rented, or used by third parties.
Yes.
This is a huge property. I know, I've been there. That seems pretty broad to me, and here's the affidavit.
Listen.
At least 2/3 of it is totally blacked out.
2/3.
Remember?
2/3 of it is totally blacked out. Man, I would think that when it comes to a search of the previous president's residence, you want to be above reproach. Blacking out things now? Come on now.
Remember this? And this redacted search warrant affidavit.
Listen.
It says, among other things, under 18 U.S. Code 793, whoever having unauthorized possession of, access to, or control over any documents or information relating to the national defense, which information the possessor is reason to believe could be used to the injury of the United States or to the advantage of any foreign nation, willfully communicates, delivers, and on and on. Espionage Act. Any person, but not the President of the United States, at the time of the removing of the documents, or even the former President of the United States.
Listen.
This is incredible.
Yes.
This is a defective search warrant on many grounds as far as...
So Mark has went back to what happened in Mar-a-Lago, okay? He's setting the stage on this Presidential Records Act. Listen, all my legal eagles, listen, here we go.
I'm concerned. What about the Fifth Amendment, due process?
What about the Fifth Amendment?
Has Trump received due process? What does it say, the Fifth Amendment? Your Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law.
Yes.
Obviously, that includes the right to a lawyer.
That's
even the
correct.
Mirandizing of a mass murder. You know, you have a right to a lawyer. You don't have to speak to us. All right, I'll take the lawyer.
Yes.
Because it's believed correctly, you cannot be properly defended if you're accused by a government. And yet, in the case of Donald Trump, his lawyers were brutalized.
Ooh.
In Washington, D.C. court, judge rules Trump lawyer must testify in documents inquiry. New York Times. A federal judge has ruled, this is in March, that prosecutors overseeing the investigation of the former President Trump handling of classified documents can pierce assertions of attorney-client privilege and compel one of his lawyers to answer more questions before a grand jury. In making her ruling, Judge Beryl Howell, this is on the last day she served on the court, then she retired, an Obama appointee, found that the government had met the threshold for a special provision of the law known as the crime fraud exception. That provision allows prosecutors to work around attorney-client privilege when they have reason to believe the legal advice or legal services have been used in furthering a crime. This is extraordinary.
What's the crime?
To do this against a former president, the leading candidate for the Republican nomination. Who has
his own attorneys had to testify against him. And they're saying that it was because of the crime fraud exemption. So my question is, what was the crime? And this was before the indictment. What was the crime? What was the crime? Keep going.
Authority to remove documents? No statute can trump the Constitution of the United States. Why does the president have this authority? Because he is the executive branch. That's why.
Exactly. Let me say it again. Hold on. Let me come to me real fast, and I'll go back to Mark, guys. Okay, real quickly. Okay, we have three branches of government. Okay, a little civic lesson. You have the legislative branch, which is the House and the Senate. You have the judicial branch, all the courts, and then you also have the executive branch, right? Which is the president. Now, watch this. Now, the legislative branch has two legs of government. All right, Senate and the House. So you have two big bodies, and the House is bigger. Then you have the judicial branch. There's a whole bunch of courts. You have the district courts, county courts, state courts, federal courts. You have a whole bunch of courts. You have Supreme Courts. You have all of these courts, right? All these courts. So you have multiple entities. The president is different. It's different. The executive branch is the president. He is it. He's the only branch of government when all is invested into one person. He is the branch. He is it. That's it. Not the other entities in the executive branch. He himself is the executive branch. Let's keep going.
He doesn't report to inferior employees. They report to him.
Exactly.
They're not even in the Constitution. He's in the Constitution. And not only that, a liberal Democrat-appointed federal judge agrees with me. Her name is Jackson.
Wait a minute.
Bill Clinton had stuff in his sock drawer.
What? Wait a minute.
And Judicial Watch sued, and they said, we want that stuff. And in part, here's what Democrat, another Obama-appointed judge, said in response in defense of Clinton.
Yeah.
Under the statutory scheme established by the Presidential Records Act,
Here we go.
the decision to segregate personal materials from presidential records is made by the president.
Wow.
During the president's term and in his sole discretion.
This is a federal judge saying this. Under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term in his sole discretion, which means he makes the decision. Let's keep going.
That's what she wrote in March 2012. It was never appealed. She said, since the president is completely entrusted with the management and even the disposal of presidential records during his time in office,
Yes.
it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. She said,
What he considers his personal records. What he considers, right? And I'm going to go a little deeper in a second on this as well also. Here we go.
that he has complete authority to make such decisions. But what about the Espionage Act?
Wait a minute.
Remember, the Presidential Records Act does not have a criminal penalty.
Exactly. So before we go to this to the Espionage Act, now one of the things come back to me real fast that I've been hearing as well, and I've been getting some counsel on this as well, is the Presidential Records Act is really only the records that the president himself creates, and so okay, not what the CIA does, not what the FBI does, not what any other entity in the executive branch. They're saying, well, that's not covered under the Presidential Records Act. Well, that can't be the case because per the Constitution, the president himself is the executive branch, not the CIA, not the FBI, not the Department of Justice, none of that. They report to him, not he report to them. So whatever he creates and what is given to him as president, he himself solely has the authority. That's what Judge Jackson was saying. He solely has the authority to declassify or classify. He is the executive branch. Not based on what Liddell said, based on the Constitution. He is the branch alone. He is. Let's keep going.
Espionage Act. It would be 18 U.S. Code, Section 793, gathering, transmitting, or losing defense information. Well, what about that? October 2022, the American Bar Association, hardly a conservative organization, talking about the Espionage Act, this case, and presidential powers. Here's what they say. They conclude this: the scope of the documents taken by investigators from Mar-a-Lago is not publicly known, nor have any charges been filed. Of course, they have been now.
Yes, not
The Constitution, executive orders, and case law clearly give the president broad authority to classify and declassify documents.
Wow.
Similarly, prevailing law also requires federal officials to follow certain procedures in declassifying documents. Federal officials, the president is the president.
Yes.
To establish specificity.
Now, look at this. Similarly, a prevailing law also requires federal officials. The president is not official, and is not a federal official. He is the president. He is the branch himself. Keep going.
And memorialization for future handling. but the extent of a president's legal authority to unilaterally declassify materials without those formalities has yet to be challenged in court. So what we have here is a rogue prosecutor, rogue attorney general says, okay, we'll challenge it in court. We're indicting you. Is that the way, ladies and gentlemen, we're supposed to figure this stuff out, even if you believe there's some conflict or confusion? No, I don't think so. That's not the way it's supposed to work at all. Now, what about this issue of obstruction, ladies and gentlemen?
Listen.
The Department of Justice took a position on obstruction when it came to the Espionage Act, the Presidential Records Act. They took a formal position when it came to the former Secretary of State. The Democrat nominee for president in 2016, Hillary Clinton. They said, we will not prosecute such cases. That was the position of the Department of Justice. That's their precedent. And the Hillary case is much worse than you know. Peter Van Buren, a national security attorney and formerly of the State Department, he wrote a commentary in Reuters. He said, there was no electronic connection, remember all the emails and the servers, between the government's classified systems and Clinton's unclassified server. This indicates that on 110 separate occasions, Clinton and or one of her correspondents had to have retyped or copied and pasted information from a classified format. There's no other method to transfer data. Classified markings such as top secret were removed in the process. Though Comey at the time did say some marked emails classified were found on the server. He's saying there were more than some. There were a whole lot. He goes on, Hillary Clinton's earliest statements that no classified information traversed her server later changed to no marked classified information. Comey explained emails found in others' inboxes, messages not turned over by Clinton to the State Department were work-related. Clinton claimed she turned over all work-related emails. Despite this, the questions of perjury and obstruction of justice were not addressed. In addition, Comey stated Clinton's lawyer deleted all emails they did not turn over to the Department of State and then clean their devices in such a way as to preclude complete forensic recovery. He added, it's also likely that there are other work-related emails they did not produce to State and that we did not find elsewhere. None of this was addressed in the context of destructive evidence. In other words, none of it was addressed by the Department of Justice in relation to obstruction of justice or conspiracy to obstruct. The director of the FBI labeled the leading contender for the presidency and her staff as extremely careless in the handling of America's secrets. In the current political climate, this is generally seen as positive news by Clinton supporters. The new standard apparently being not under indictment. Few believed rightly or wrongly that Hillary Clinton would face criminal charges over her handling of classified material, yet the questions not addressed by the FBI remain. Obstruction, false statements, which they've now applied to Donald Trump. That was the position of the Department of Justice 11 years ago.
Concerning the Hillary thing, Hillary in the context of this is considered, because she was the former Secretary of State, a federal official, which means she actually works within the executive branch. Remember, the executive branch is the president is the executive branch himself. He alone is executive branch. All entities within the executive branch, the Department of Justice, FBI, CIA, NSA, ATF, you name them, all the secretaries of said department, labor, those are entities in the executive branch. He alone, not per Liddell, but the Constitution, he alone is the executive branch. It's different from the legislative branch and different from the judicial branch, because they have several different entities there, right? That's why his is so unique. The executive branch is so unique. It's all power is vested into one person. That does not mean he has authority over the other branches. No. What it's saying is different than the other branches. All executive authority for that branch is in one person, the president himself, right? Now, Hillary Clinton, she may have been covered under another records thing. I don't know what that is. As well as I'm not going down that road. He was pointing that out because she would fall under the federal official title, not the president. The president is executive branch. He so has the authority to deem what's classified, what's not, what's his, what's not based upon what Liddell said. Judge Jackson said it as well, and the Constitution said it as well also. That's the difference here. All right, guys? So now, again, I told y'all what my legal ego shift for this, guys. We got one more thing to look at, guys. We're gonna go a little bit deeper on the Espionage Act real fast, okay? Again, thank y'all for your patience and your time. This took a lot of time to put together, guys, because I had to make a lot of phone calls to a lot of attorneys as well, and also listen to this as well. This is pertaining to the Espionage Act, because remember, when it comes to the come back to me real fast. When it comes to the Presidential Records Act, it is a civil issue. There's no criminality within that act. And that act was made specifically for the president, specifically for him. That's why it's called the Presidential Records Act, right? That's there for that, all right? So you have a statute literally made for the presidents and it's really talking about the documents themselves. Then you had a federal judge come out and rule on that the president has the sole authority there, guys. That was in the Bill Clinton scenario. This is after his term, not during Clinton's term, after his term, guys. So I'm like, that makes some sense. What I've been hearing a lot on TV a lot of times is with the president followed the protocol. He is the protocol. He is the protocol because he is the branch. He is the full protocol, guys. Not based on what the Dale said, based on what the Constitution stated, and also based on what Judge Jackson said it, and there was no appeal. No appeal, all right? And that was for Bill Clinton. Let's keep going. Let's jump into the Espionage Act, guys. Thank you guys so much for your patience. Took me a little bit to put this one together because I'm not an attorney, guys. I'm a business guy. So here we go.
A president does not have to comply with a decision made by a department or an agency, and we're going to follow these rules when it comes to declassification.
Yes.
Well, go ahead. But as president, doesn't apply to me.
Exactly.
There are three things at play here with the attack on Donald Trump. The Presidential Records Act, which was passed in 1978 and took effect in 1981 during Reagan's administration. The Espionage Act, which was passed in 1917, has subsequently had some amendments.
Okay.
The purpose of which was to enable Woodrow Wilson to throw people in prison who spoke or protested in opposition to World War I.
Okay.
And he threw 2,000 people in prison, including Eugene Debs, who ran for president as a socialist, I think in the end about 5 times. But his 4th time, he ran from prison. And he got 6% of the vote. So it's a notorious law in many respects. Now, that law has been used to prosecute various people who have sold espionage, spied on the United States, documents to the Russians or to other countries, and given it to them, or they have not properly handled such documents. Under Section 793, lowercase e, 793E. It's a fairly ambiguous section of the Espionage Act, but they like to use it. That is, prosecutors more and more. So you have these two laws, and then thirdly, you have the power of a president of the United States to declassify. So let me break them down and see what's at play here. First of all, the key law is the Presidential Records Act. Notice the first word, presidential.
Listen.
What happened before 1978 is a president could take all the records he wanted.
That's correct.
Classified or not classified.
That's correct.
And they were considered personal. They could tell the archives or not tell the archives. Some of you may collect these documents. Some of you may have seen them. You have brokers who sell them. Official presidential documents. I'll give you a perfect example. Some time ago, I purchased one of these documents. Legally, of course. And it was the first appointment of an associate justice to the United States Supreme Court.
Oh, cool.
Now, that's a powerfully important document.
It is.
Today, that document would belong to the government. It would have been controlled first by a president, President Washington, and then eventually it would go to the National Archives if there was such a thing. But not back then.
Okay.
And not prior to 1981.
Okay.
And so that document, which was signed by George Washington,
Okay.
which was signed as accepted by the Chief Justice of the Supreme Court, who's in the Constitution, John Jay, you may have heard of him,
Okay.
the minor author of the Federalist Papers. He was the first Chief Justice. So Washington signs the appointment.
Okay.
He gives it to John Jay, and on the back, John Jay signs it as received and accepted, and so the term begins. So back then, by the way, as a footnote, Washington would nominate somebody on paper,
Yeah.
they'd be approved within 24 hours, and then they'd serve on the Supreme Court. That's how it worked. This was the first Associate Justice of the Supreme Court. Where did this document wind up? Well, I always think to myself when I have documents like this, it's almost not fair. So I gave it to Hillsdale College.
Okay.
You can find that document today at Hillsdale College in their Washington, D.C. Facility, which has other documents I've given them, including a copy of the Federalist Papers and so forth.
Sure.
It doesn't belong to the government.
Okay.
So there was a decision made after Nixon's presidency, we don't want to do this anymore.
Okay.
So they paid Nixon several millions of dollars for his papers. This law was passed, signed by Jimmy Carter in 1978, the Presidential Records Act, and then it went into effect beginning with the Reagan administration.
Correct.
And it provides, it codifies, as a matter of federal law,
Okay.
the manner in which these documents will be handled by a president and a former president. And among other things, it gives enormous authority to the president who becomes the former president because, remember, keep in mind what existed before the Presidential Records Act. The president had all the authority
Yeah.
when he left office over the documents, correct? So the idea that the Espionage Act would apply now to any president who takes documents is really quite preposterous.
Interesting.
There's no mention, no footnote, no notation, nothing to the Espionage Act when they passed the Presidential Records Act. That's number one.
Okay.
Number two, the Presidential Records Act provides a fairly elaborate civil process. Civil process. If there's a disagreement between a president, that is a former president, and the National Archives, you don't trigger the Espionage Act, even if the FBI and the Department of Justice, but especially the National Archives, doesn't like the fact that a quote-unquote president is dragging his feet, or he's got national security information, and so forth and so on. Let me tell you a little secret that's not so secret.
Listen.
If a former president of the United States wants to be read into intelligence activities that are taking place today, he can be.
Ooh.
And he often is. Because
Wait a minute. So that is correct. Former presidents are read in to what's for national security stuff. Currently, we're talking about Jimmy Carter, Bill Clinton, Bush, the first Bush before he left, before he passed away, the second Bush, Obama, Trump, and also Biden. These presidents are often, to this day, still briefed on national security stuff. Interesting.
Because it's thought that they should know about these things, if they want to know about these things, for a variety of reasons, including the fact that they might be asked something and the sitting president may not want them to reveal anything.
That's
so they're
correct.
explained why certain things are happening and so forth.
Wow.
And there's a lot of reasons for that. But that said, so a president is treated differently. I heard Andy McCarthy on Fox say, presidents know better than somebody else who's caught with these kinds of records and won't give them up. It's called the Presidential Records Act, not the Colonel Records Act, not the General Records Act,
Yes.
not the Secretary of State Records Act, the Presidential Records Act.
Yes, his name is in the act.
Then we get to this issue of the Espionage Act.
Here we go. Okay.
I challenge you to look it up. and to look at the different titles within the act, which have absolutely nothing to do with a former president. Talks about
This is the reason why I respect Mark Levin on this topic. Is he's saying, go look it up. Don't take my word for it. Go look it up yourself. Someone being honest ain't gonna tell you to go look it up. But let's keep going.
spies, what's a spy, talks about maps, talks about documents, talks about electronic communications, talks about all these things that have absolutely nothing to do with a former president.
Exactly.
And then there's that section about the retention of documents.
Oh,
That if you retain these documents, the classified information, and if you retain them in a way that doesn't properly protect them, then you could be subjected to criminal prosecution under that section. Oh, wait a minute. How do you square that with the Presidential Records Act
yeah.
and the civil process they put in place? You can't. And you don't.
Interesting.
And it's interesting, the Presidential Records Act isn't mentioned once in the 49 pages, in the 38 charges, 37 of which seek to ensnare Donald Trump. Not once.
Wow.
And it's interesting that they don't mention that President Trump didn't destroy any records, that President Trump didn't alter any records, that President Trump didn't give any records to foreign authorities or sources.
Now, in the language of the Espionage Act, you have the word spies. Spies. Spies do some nefarious stuff. But I digress. Let's keep going.
He didn't sell them.
Didn't sell them.
He didn't make them public.
Not at all.
He didn't do any of those things.
None of them.
All these allegations that they've concocted against Donald Trump are a result of criminalizing what is a civil process.
Oh.
So they decide, we're going to criminalize it. And according to Bill Barr, who really has turned out to be kind of a lowlife, if you ask me, he was on TV on Fox as well on Sunday, and he says, well, they started out with the Presidential Records Act, and then they moved to the Espionage Act. You don't get to move to the Espionage Act.
Exactly.
You don't get to move to the Espionage Act.
Yes.
And nobody's ever moved to the Espionage Act. The Espionage Act hasn't been used against any president before, any vice president, any cabinet member, and so forth.
Yeah.
Obviously, Hillary Clinton was not a former president.
No, she
The
was not.
Presidential Records Act, there's a Federal Records Act, but the Presidential Records Act doesn't even apply to her, so she doesn't even have that defense. And you look what she...
That's what I mean by Hillary. She was most likely covered under the Federal Records Act. I don't know to what degree. I didn't read that at all, but that's what it is.
She did the destruction of thousands of emails, permanent destruction, the destruction of cell phones, literally using hammers to make sure they were destroyed, despite the fact they were subpoenaed by the House Oversight Committee headed by Jason Chaffetz at the time. That subpoena has the force of law, as does any subpoena coming out of the executive branch. So subsequent to that, she destroyed them. I saw Dan Abrams of Mediocreite, who's sort of the Jerry Springer of the law. You see him from time to time with these different court shows where people are beating up people and that sort of thing. He also fancies himself some kind of judge or attorney expert. Of course, he's not. He said that Hillary Clinton didn't know that they were classified, and the Inspector General later found out they weren't. Ladies and gentlemen, Hillary Clinton used that private server, and to this day, we have no idea if foreign governments accessed it.
I didn't know that.
She used private communications when she was overseas, even visiting enemy states.
Wow.
And again, to get around the formal governmental communications system that protected that information, and the requirement that they turn over all these documents and all these communications after she leaves office. Again, she was Secretary of State, not a former president. And it was later found that some of the information was classified. In fact, one expert pointed out, an expert that I pointed out to you folks, I guess it was last week, in an article in Reuters, I think it was in 2014 or 2015, who had worked at the State Department for 27 years, and was an expert in this area, and he said they have no idea how much classified information Hillary Clinton was able to access or was used by any foreign country, because her system was not locked into the Secretary of State's system at the State Department.
Huh?
She received this information, and he argued that when they put it on her system, they would take the headers off, the so-called cover pages, if you will, for electronically communicated classified information. So, furthermore, he points out, they never investigated her for perjury or obstruction. Never.
Wow.
Why? Because they didn't criminalize the investigation. That's why. They never criminalized the investigation. In fact, the official position of the Department of Justice is we don't charge in cases like this.
Yeah.
Remember Comey? He made the decision for the entire department. So this...
Now, Comey did say no reasonable prosecutor would bring this forward. That's what he actually said. Well, based on what I'm hearing here is a lot of this is kind of theory, but I'll get into that in a second. Here we go.
This issue of obstruction, the official position of the Justice Department was, up until the other day, that they don't charge former officials with obstruction under the Espionage Act.
Really?
And yet Donald Trump is charged for basically willfully retaining documents that he shouldn't have. 31 counts.
Interesting.
31 counts. Then there's this issue of declassification.
Okay.
I told you the ABA, which is a liberal organization,
Really?
they even said that this is an open question. Well, it's really not an open question.
Okay.
All these individuals and all these departments they work for and regulations and all, they're not in the Constitution.
No, they're not.
The
Interesting.
Constitution didn't even conceive of such a massive bureaucracy creating so many classified documents. You know, classified. Then if you violate, oh, now we got you. Now we got you. It used to be tough to get documents classified. Now it's very simple. So this creates a huge problem as well. What's really worthy of classification, what is not? Now that said, President of the United States is the executive branch.
Yes, he is. He is it. Yes.
All these other departments we talk about didn't exist. Department of Justice didn't exist. Attorney General, not in the Constitution. U.S. attorneys didn't exist. Okay? National Archives didn't exist. FBI didn't exist. None of it. The president is the executive branch. All these other things flow from him, but without him, there is no executive branch. So it's well understood that a president does not have to comply with a decision made by a department or an agency, and we're going to follow these rules when it comes to declassification. Well, go ahead. But as president, it doesn't apply to me. I could look at a document and say, okay, declassified, make this available. Now, how does the president demonstrate that? Doesn't say. That's why the ABA said this is an open question.
Exactly.
President Trump and I, he probably listening to my shows, but I have said, a president can simply say, I'm declassifying this. Doesn't have to go through any process.
That's correct.
He doesn't have to say anything. He goes through the act that indicates it's declassified.
Yeah.
The problem is we have judges that don't believe in the Constitution anymore. So if Donald Trump takes a document with him, is it classified or not? Is the act of taking it with him declassifying or not declassifying? Okay, whether I'm right or wrong, again, you don't indict a former president and the leading Republican nominee to take on the existing opposition party's president. That sets up a special counsel situation to investigate Trump. You don't indict the person to figure out the answer to that question. Since that question has never had to be raised before. Why?
There you go.
Because we've never used the Espionage Act against a former president.
Want to see
That is correct, guys. So, again, thank you guys for your time. Appreciate you. I told you, legals, come on out on this one. You know, so, but yeah, here's my reaction to this, guy, because you guys have been with me for a while. And thank you guys for your patience and unpacking a lot of information. It's a lot of information. This was probably one of the toughest one I had to do. I had to do a lot of research on this as well also. Not just with Mark Levin, but other attorneys as well that I know that are in my sphere of influence. Number one, you saw Mark Levin talk about the Constitution. Why? The reason why is because the president is in the Constitution. He is the executive branch. Okay, he's totally different from the legislative branch and the judicial branch. He's totally different, guys. He himself is the executive branch. He's unique. All right, and so he talked about how the PRA, Presidential Records Act, came into being, and it was mapped out because before that time frame, the president had like and they took everything to the house, everything. So they said, well, we gotta kind of tempt these in a little bit, and so they made this act. Now I'm gonna say this here: since the president is the executive branch, he reports to nobody. Everybody reports to him in the executive branch. So there's no process at all. He is the process. He is it. Period. Not based on what I say or Mark Levin says or anyone else says. He is the branch because the Constitution said so, right? And so what actually happened is now what happens is you speed forward and the PRA is now in effect. Well, a case came up against Bill Clinton, right? And Judicial Watch wanted to get some classified tapes, right? That was in Bill Clinton's drawer of some sort. They went to the court and filed a FOIA. Said we want those, which is a suit. And what happened was when he actually did that is Judge Jackson, right, said, well, hold on. Per the Presidential Records Act, the president has the sole authority on what is declassified and what is classified. If he wants to give it up, he can, but it's under his authority alone. And she pointed back to the Presidential Records Act. Then this is after Bill Clinton's term. Well after his term. Right? And so, cool, no problem with that. And it was never appealed. So now you have the Constitution, and you have a federal judge, her coming out and saying that. And it was not appealed at all. So now you have a precedent now. Then what happens is, and then you have the ABA, which talked about, they said this is an open-ended question as far as when it comes to the Presidential Record Act. And so wisdom says this here is, well, let's test this out, because the PRA, it's a civil matter. It's not criminal at all. It's all civil. Matter of fact, I learned this as well. This shocked me. Once a president leaves, okay, they have up to, I believe it is 5 years to go back and forth between the National Archives. 5 years, right? And then during that 5 years, he can actually appeal as they're going back and forth, and extend it out for 12 years, right? For 12 years. I just said, damn, wow, Obama did this, Clinton's done this, both Bushes have done this, Carter's have done this, Reagan has done this, they've all done this. They've all done it. And another thing I learned is the one thing I've been hearing about, well, a lot of the prosecutors that are actually on TV, and I've been seeing a lot of prosecutors on TV, not constitutional attorneys, different disciplines. They were saying this here. Well, what the prosecutors were saying is, well, the Presidential Record Act only covers what the president creates. And that's not the case, because of the fact that he himself is the executive branch. So everything flows from him. So yes, anything that he creates and any other entity in the executive branch, when they bring it to him, it's his sole authority on what's classified and what's not classified. So the PRA does not cover what the president creates. It's the entire executive branch, what they create. He is the branch. That's why his position is so unique. That's what's going on. And so now you have this Espionage Act coming in, and what they're saying is, well, there was a some sort of a crime or a probable cause of a crime. Well, when you read the indictment, it's all process stuff. Like what was the crime? You got your documents back. Nothing was destroyed. Nothing was done to the property to the papers. Matter of fact, during this whole scenario, President Trump and his team were actually going back and forth with the archives, and the archives doesn't have any authority at all of the documents. It's the president himself. This information, this was a fairly good civic lesson for me when I was walking through this stuff, man. I just said, wow, this is something. No matter what attorney I would go to, this is what I was getting. And I said, wow. And they were saying, because he is the executive branch. He alone is. So for them to move this over to the Espionage Act, that's why the ABA's of saying was so pivotal. They were saying this is an open-ended question. Well, what they were trying to do was now this whole indictment from a legality standpoint, not based on what Liddell is saying, or these are what attorneys are telling me, is that these are legal theories. These are legal theories. Espionage Act. Charging the president with Espionage Act is a legal theory. And if you knew it in the indictment, there was no mention of the Presidential Records Act. Why is that? Can I ask these questions? The same thing when it comes to New York. It's a legal theory. So there's a lot of theories being tested here. And how they're testing these theories out is by indicting a former president while there is an election going on. Man, that is something there, brother. That is something there, man. So it's just this here was probably the toughest. I'm gonna say the toughest. It was the longest education that I've ever got with this here, because I got a crash course on civics, and so it was something to understand the awesome power that the executive branch actually has. And to be honest with you, a lot of that power has been just gifted over to him. Be honest with you, by the legislative branch, they just kind of gifted it over to him. Executive orders, although that is the president's prerogative, a lot of the EOs that the president writes is because the legislative branch won't do their job. So I mean, it goes. And the one thing I could get painted is the court case does not have a standard. Exactly. What I'm saying by that is this here is they are testing out these theories in the court system against a former president in the middle of an election. So they're testing, these are theories being tested by indicting somebody. And that somebody is a former president. And to this day, former presidents do still get those national security briefings if they want them. That right there shocked the hell out of me, guys. But guys, man, this is called the Countermove, guys, for a reason. This is the longest Countermove I ever did, guys, to be honest with you. So again, what is the Countermove? I always say, guys, peep it, sweep it, and then keep it, guys. I always say this is examine your current situation. Peep it. Well, you've gotten this information. Don't just take my word for it, guys. Do your own research. How is your current situation going right now of this climate, whether it be the legal system or this court system? This is concerning this case. If it's uneasy for you, you gotta make some decisions now. All right. Number two, and that's why I say, are you getting accurate news reporting? Okay, you're gonna really have to become an expert journalist and do your own research. All right, confirm. All right. Number two, I always say this here. Peep it, sweep it. Are you operating on accurate information? That's why I say confirm. When you listen to a liberal outlet, conservative outlet, or independent outlet, trust but verify. I wouldn't even say trusted. I would say verify it. Verify. That's the reason why I didn't stop at Mark Levin, even though I know Mark. He was a good friend of mine. What I'm saying is this here. I talked to some other attorneys as well about what was going on. And I got a crash course on what's going on, guys. All right. All right, cool. Number three, I would say keep it. You got to begin to think generationally. All right. What I mean by that is if what you've seen is making you uneasy, right? You got a voice. Vote. It's up to you. Vote. You can sit in the corner and bitch and moan and complain. Go do something about it. Go volunteer somewhere. Educate somebody. Get off your behind and go do something. Be the change that you're wanting. Be the change that you're wanting, all right? And if you like what's going on, okay, keep voting that way. But you get off your butt and you're going to be the change that you want, all right? No matter what it is, sitting on the sidelines is not an option at all. Get off your ass and go do something, guys. All right, guys. But guys, man, that's it. Whew. Man, that was a lot, yo. Now that was a lot, man. Woo, my word. Instagram is over here lightening it up a little bit. It's all good, baby. Ain't no thing. Thank you guys for your time. Give me your thought. What do you think about it? Hey, let's sit down and reason together, guys. This right here was really fun, but it was pretty exhausting because I had to fit this into my busy schedule as well for business guys wise. All right. Also, guys, I gotta say this, guys. Every single Friday night at 9 p.m., guys, Suni and Mo have a show called Somewhere in the Middle, guys. It's really on Tuesday and Friday, guys. But guys, here's a little bit of a snippet of it. Here we go.
Now we're about to get
I went down.
facts on facts on facts. Hello.
All right, guys, that was Somewhere in the Middle with Suni and Mo. Man, on Friday or Tuesday, they've actually added another show, guys. Man, get your booze, sit down and listen to them. Sometimes you may agree with them, sometimes you may not. That's okay. No problem with it at all. If you're entertained, grab your boo and sit down and talk to them. And Mo has this thing called Mo's Thoughts, or Thoughts with Mo, whatever it's called, y'all. It's the funniest thing ever. It's the funniest thing ever, man. I tune in just to hear that. That's it, guys. But guys, man, thank you for your time. God bless you, man. Thank you for kicking it with your partner, man, through this whole thing. And you know how I end it every single time, guys. Every single time before you leave. And while you can, you see me looking better than you. Take that down picture and give it to your mama down. Now say it with your chest and holler at your partner. Peace, guys. God bless.
Long live the king.